She says, father testified that the abuse stopped. This is concerning. How did he know when the abuse had stopped? The court finds that this was an admission of direct knowledge that only he, as the perpetrator, would have. On December 11th of 2020, Judge Amesbury, he officially stopped the abuse because he put protective orders on my daughter. What brought us into a custody trial was these orders were not being followed. And on March 12th, 2024, which was 4 years after this judge placed them protections on my daughter, Sadia was listed on my witness list to come to court and testify. A comprehensive brief that I submitted to her was the previous year. So she still didn't come up with a decision as to whether my daughter was going to be able to come to court and testify who she wanted to stay with. And so on March 12th, 2024, this is when they initially took my rights away, page 200 of the transcripts. I said, what I wanted to say is, like, whether my witness is going to be able to take the, and I was ready to say stand, and she cut me off and she said, yes, with Sadia, you mean? I said, yes. She says, so the request I have to still weigh that. On page 201, I said, yeah, because she used to have meltdowns when going to mom's house, but since the abuse stopped, now she just kind of says no. The court says, okay. And then they make a ruling saying dad testified the abuse stopped. The court finds this was an admission of direct knowledge that only he, as the perpetrator, would have. So I say to the Superior Court, the cessation of the abuse became apparent when the minor accumulated to the abusive environment, leading to an official recognition that the abuse had ceased. Despite this, all involved parties were aware of the ongoing abuse as evidenced by Exhibits H and I. The abuse was formally stopped when a competent judge issued an order imposing restrictions on the abusers as documented in Exhibit B. During the proceedings on March 24, as recorded in the transcript on page 201, the appellant specifically requested the trial court judge to permit the minor to testify regarding her preferred custodial arrangement. It was noted that the minor previously experienced severe emotional distress when transitioning to the mother's care. This all can be seen in Exhibits E, F, and G. So following the abuse, these episodes appeared to become less severe due to how long it took to realize what was happening due to the child being nonverbal. But the child appeared to be suffering from trauma after the abuse officially stopped due to an order restricting the abuser no unsupervised contact with the minor. The minor still continued to express a preference to reside with her father. The trial court's efforts to misrepresent this information and simultaneously deny the child being able to express her preference are considered reprehensible and not in the best interest of the child. The court's characterization of the father's knowledge regarding the cessation of abuse appears to be a misinterpretation of the evidence presented and prejudicial. The father's actions demonstrate diligent parental oversight rather than insider knowledge of abuse. The father systemically monitored the child's behavior in response to changes in behavior. He observed changes in the child's meltdown patterns and overall demeanor when spending less time with the specific individual, Jasmine. The father noted unusual physical evidence sent during an unexpected early pickup. He documented the child's behavior changes over time, including the apparent cessation and subsequent resurgence of concerning behaviors. This interpretation by the court could be challenged on several grounds. Misapplication of evidence. The court appears to have fabricated the father's observational data and testimony as insider knowledge. Violation of due process. By making unfounded assumptions about the source of the father's knowledge, the court may have infringed upon his right to a fair hearing. Improper standard for parental rights. The court's statement suggests a prejudicial view that could impact decisions about parental rights without clear and convincing evidence. Failure to consider alternative explanations. The court seems to have disregarded the father's documented efforts to understand and address his child's behavior changes. Potential bias and fact-finding. The court's statement indicates a possible predisposition against the father, which could taint the entire proceeding. So the judge not only tried to frame me of sexually abusing my child, but then cut off all phone communication to where I can't even talk to her no more. So this order, May 3rd of 2024, I seen my daughter one time. The second time that I seen my daughter was February 14th of the following year. He subjected me to 1 to 4 hours per week supervised, And the first supervised visitor, he was charging $80 per hour. She also subjected me to go to counseling in the Poconos, which is an hour away from where I live. And the initial evaluation, they want $600. And then I'm also required to pay for mom's counseling is another $600, and then pay $140 per session for each of us.